Number 12, certified foreign records of regularly conducted activity in a civil case, the original or a duplicate of a foreign record of regularly conducted activity that would be admissible under 8036 if accompanied by a written declaration by its custodian or other qualified person certifying that the record 8 was made at or near the time of the occurrence of the matter set forth by or from information transmitted by a person with knowledge of those matters. B was kept in the course of the regularly conducted activity, and C was made by the regularly conducted activity as a regular practice. The declaration must be signed in a manner that, if falsely made, would subject the maker to criminal penalty under the laws of the country where the declaration is signed. A party intending to offer a record in evidence under this paragraph must provide written notice of that intention to all adverse parties and must make the record and declaration available for inspection sufficiently in advance of their offer into evidence to provide an adverse party with a fair opportunity to challenge them. With a fair opportunity to challenge them. With a fair opportunity to challenge them. Rule 903. Rule 903. Subscribing witness testimony unnecessary. The testimony of a subscribing witness is not necessary to authenticate a writing unless required by the laws of the jurisdiction whose laws govern the validity of the writing. Article 10. Oh, shit. 1001. We only got 1100. Only thousands and 1100s, and then it's over. And then it's it. That's it with the... Yeah, you thought it was just going to be... It's not. Basically, any person, it's like... The one thing the Protestants got right over the Catholics is that, you can interpret the Bible for yourself. You don't need some authoritarian fascist schmegma, dickhole schmegma asshole to... No, this is how I read it, so you have to... Rule 1001. Contents. Article 10. Contents of writings, recordings, and photographs. Rule 1001. Definitions. For the purposes of this article, the following definitions are applicable. Number 1. Writings and recordings. Writings and recordings consist of letters, words, or numbers, or their equivalent, set down by handwriting, typewriting, printing, statting, photographing, magnetic impulse, mechanical or electronic recording, or other form of data compilation. Number 2, photographs. Photographs include still photographs, X-ray films, videotapes, and motion pictures. C. Original. An original of a writing or recording is the writing or recording itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of a photograph includes the negative or any print therefrom. If data are stored in a computer or similar device, any printout or other output readable by sight shown to reflect the data accurately is an original. 4. Duplicate. A duplicate is a counterpart produced by the same impression as the original or from the same matrix, or by means of photography, including enlargements and miniatures, or by mechanical or electronic re-recording, or by chemical reproduction, or by other equivalent techniques which accurately reproduce the original. Rule 1002. Rule 1002. Requirement of original. To prove the content of a writing, recording, or photograph, the original writing, recording, or photograph is required, except as otherwise provided in these rules or by statute of the state of Colorado or of the United States. 1003. Rule 1003. Admissibility of duplicates. A duplicate is admissible to the same extent as an original unless 1. A genuine question is raised as to the authenticity of the original, or 2. In these circumstances, it would be unfair to admit the duplicate in lieu of the original. 1004. Rule 1004. Admissibility of other evidence of contents. The original is not required. Another evidence of the contents of a writing, recording, or photograph is admissible if 1. Original is lost or destroyed. All originals are lost or have been destroyed unless the proponent lost or destroyed them in bad faith. Or 2. Original not obtainable. Original not obtainable. No original can be obtained by any available judicial process or procedure. Or 3, original in possession of opponent. At a time when an original was under the control of the party against whom offered, he was put on notice by the pleadings or otherwise that the contents would be a subject of proof at the hearing, and he does not produce the original at the hearing. Or 4, collateral matters. The writing, recording, or photograph is not closely related to a controlling issue. Rule 1005, public records. The contents of an official record or of a document authorized to be recorded or filed and actually recorded or filed, including data compilations in a form if otherwise admissible, may be proved by copy, certified as correct in accordance with Rule 902, or testified to be correct by a witness who has compared it with the original. If a copy which complies with the foregoing cannot be obtained by the exercise of reasonable diligence, then other evidence of the contents may be given. Rule 1006. Rule 1006, summaries. The contents of voluminous writings, recordings, or photographs which cannot conveniently be examined in court may be presented in the form of a chart, summary, or calculation. The originals or duplicates shall be made available for examination or copying or both by other parties at reasonable time and place. The court may order that they be produced in court. Rule 1007. Rule 1007. Testimony or written admission of party. The contents of voluminous writings, recordings, or photographs which cannot conveniently be examined in court may be presented in the form of a chart, summary, or calculation. The originals or duplicates shall be made available for examination or copying or both by other parties at reasonable time and place. The court may order that they be produced in court. Rule 1008. Functions of court and jury. When the admissibility of other evidence of contents of writings, recordings, or photographs under these rules depends upon the fulfillment of a condition of fact, the question whether the condition has been fulfilled is ordinarily for the court to determine in accordance with the provisions of Rule 104. However, when an issue is raised, A, whether the asserted writing ever existed, or B, whether another writing, recording, or photograph produced at the trial is the original, or C, whether other evidence of contents correctly reflects the contents, the issue is for the trier of fact to determine, as in the case of other issues of fact. And that ends the thousands. Now we are on to 1100. 1101. 1101. Rule 1101. Applicability of rules. Applicability of rules. A, courts. These rules apply to all courts in the state of Colorado. These rules apply to all of the courts in the state of Colorado. B, proceedings generally. These rules apply generally to civil actions, to criminal proceedings, and to contempt proceedings, except those in which the court may act summarily. C, rule of privilege. The rule with respect to privileges applies at all stages of all actions, cases, and proceedings. D, rules inapplicable. Rules inapplicable. The rules other than with respect to privileges do not apply in the following situations. The rules other than with respect to privileges do not apply in the following situations. 1, preliminary questions of fact. The determination of questions of fact preliminary to admissibility of evidence when the issue is to be determined by the court under Rule 104. Number 2, grand jury proceedings before grand juries. Number 3, miscellaneous proceedings. Proceedings for extradition or rendition. Preliminary examinations in criminal cases, sentencing or granting or revoking probation. Issuance of warrants for arrest, criminal summonses and search warrants. And search warrants and proceedings with respect to release on bail or otherwise. E, rules applicable in part in any special statutory proceedings. These rules apply to the extent that matters of evidence are not provided for in the statutes which govern procedure therein. Rule 1102, no Colorado rule codified. No Colorado rule codified. Rule 1103, title. Rule 1103, title. These rules shall be known and cited as the Colorado Rules of Evidence, or CRE. Oh, shit. I didn't know that. CRE. Okay. CRE Editor's note, see CRS 1325-139, 1325-139, criminal action, interference with witness forfeiture by wrongdoing. When a party to a criminal case wrongfully procures the unavailability of a witness, a statement otherwise not admissible pursuant to the Colorado Rules of Evidence as offered against the party that was involved in or responsible for the wrongdoing that was intended to and did deprive the criminal justice system of evidence is admissible as an exception to the hearsay rule, except that such a statement is not admissible unless the proponent has given to the adverse party advance written notice of an intention to introduce a statement sufficient to provide the adverse party a fair opportunity to contest the admissibility of the statement. In determining the admissibility of the evidence, the court shall determine prior to the trial whether the forfeiture by wrongdoing occurred by a preponderance of the evidence. Whether the forfeiture by wrongdoing occurred by a preponderance of the evidence. Effective June 26, 2020. Effective June 26, 2020. So, what is your point? What is your point? I'll tell you what the point is. The point of the rules of evidence is to make sure that you want to get to the truth, right? You want to get to the bottom of things. You want the peace, love, justice, right? We're not just being judges and prosecutors and cops here for our fucking health, right? In fact, it's almost like small towns don't realize this, but big cities have to deal with real shit. So basically, if it's not a big fucking thing, they're kind of like, oh my God, it's not a big thing. No, I don't even want to deal with it. It's not a big thing. And so that's, that's Jesus Christ. That would be, So the point being, Colorado Rules of Evidence and the criminal procedure and all the rules, really, the rights and the freedoms, all of it, is encompassed in Colorado law. But the point is, there's a reason for each one of these, there's a point for the rules of evidence is to say what evidence is allowed to be presented, what evidence is not allowed to be, what is fair, what is not fair. And so you want to get to the truth, right? You want to get to the truth, but you don't want to interfere with people's rights, but you want to get to the truth, right? And a lot of times, sometimes a cop will speed, right, to catch a speeder. So they break the law in order to catch a lawbreaker. And so people will be forgiving of a police action if it's something like that. So we want it to be fair, right? If one person says, hey, he punched me, maybe he did. Maybe it's an assault. Maybe it's self-defense. Maybe it's a police action. Maybe he was coming up on him or some shit. And he was like, hey, what the hell's happening? And just, kind of popped him one. Well, what'd you do that for? You was just coming up on me. I remember one guy gave me a suggestion. He's like, hey, you know how I deal with people? And I was like, how? He says he would, walk really fast, really aggressively towards them. That's scary. That makes me think you're about to do something. So what's my point? My point is that all this, the criminal procedure, is to be fair, right? So if I was to say, hey, Michael Gonzalez, right? Michael Gonzalez, no, you fired warning shots. No, you fired warning shots, and that scares me. You firing warning shots when I was messing with you with my big rig, that scares me. So now Michael Gonzalez has to go through the exact same criminal justice system that I have had to go through. Michael Gonzalez has to get arrested. He's got to go to jail, get a bond, and then he's going to have to relinquish all of his guns, including his ammunition, and a whole bunch of other things. Be, treated like crap, be disrespected here and there. But what's good for the goose is good for the gander. Due process is, what's fair. In, applicability of the administration. The process has to be fucking fair. The process, the rule of law. We all have to obey the law. Nobody can felony menace anybody. Nobody can go with a firearm, with a deadly weapon, a bludgeon or a knife or a gun, and try to scare other people. In fact, I would say that not only are we not to scare each other, we shouldn't even worry each other. There's a law in Colorado that says dogs should not worry the livestock. So the dogs worrying livestock law is if there's a herd of cattle and your dog runs out of the yard and, is all the way over there by the cattle and it's chasing the cattle and chasing the cattle and chasing the cattle. then the person could shoot him, and they would be protected under Colorado law. That's why these motherfucking dickheads with the wolves keep on. They don't make any sense. Basically, you're saying you think the federal government can fuck you over in the institutions of Colorado. You don't have any confidence or faith or, you don't have any belief in the institutions of Colorado. But all the court systems and all the thing is through Colorado. So it'll be the, court judge. It'll be the Colorado judges, Colorado DAs, Colorado cops, the Colorado whatever, and it'd be a Colorado people that'd be in the jury. So let's say the feds do get a hold of it, it'll have to be 12 people in that jurisdiction. You tell me that 12 people in the jurisdiction are going to tell me that you're going to watch a wolf eat your baby sheep or eat your baby goat or eat your damn calf? Fuck you. I say go ahead and shoot that wolf. If it's eating your baby calf, shoot that wolf. There's no jury in the world that would convict you, and Colorado law defends you. You can't even worry the livestock. So if a wolf is eating your chickens, if a fox is in the hen house, then that's a cause for alarm. That's more than worrying, right? That's killing, that's murdering, that's like one of the big fucking things, right? But to worry, could you imagine? So once we get, comfortable with not doing big fucking crimes with each other, then we can start to pinpoint some of the smaller things. But can you imagine if we could actually get to a point where we're not going to even worry each other? We're not going to worry human beings. We're not going to worry not just the cattle, but we're not going to worry people. We're not going to worry their pets. And we're not going to worry their goldfish, okay? So basically what's good for the goose is good for the gander. What's good for the cattle is good for the goldfish. What's good for the heifer is good for the woman. What's good for the bull is good for the man. So the whole point of having a criminal procedure is so that when I say, hey, Michael Gonzalez, you fired warning shots at me, not to defend yourself, not for a police action, but just because you want to scare me. You just want to give me a little scare. Then that's all she wrote. That's all you need is an accusation. And then a police officer goes with that accusation, goes to his house with 5, guns all pointed at him. And, well, you know the rest of the story. September 17th, 2021. So it should be fair, right? It should be fair. You're going to say, hey, John Masters, you can't felony menace with your warning shots. That's felony menacing. Which is kind of crazy because I thought all those right-wing authoritarian fascist sons of bitches, I thought y'all a bunch of tough guys. What? He fired a warning shot. Oh my God. Oh my God. You did drive-by shootings. I know, but I didn't want to. You can't do a warning shot. I didn't drive to your house. You drove to. Okay, all right. You're the initial aggressor. I was walking my dogs in the backyard. What's good for the goose is good for the gander. So let's assume Robert Pickerel. I accuse Robert Pickerel of a felony menacing crime. Therefore, Robert Pickerel will have to go through the same criminal procedure. He'll have to go, with the same rules of evidence. And at the end of the day, it comes to a jury trial, right? What does 6 or 12 of your peers? What will 6 or 12 of your peers at the end of a fucking jury trial? One side presents their case, the other side presents their case. What will that jury of your peers say about, whatever. September 17th, 2021. Or Robert Pickerel, being a felony menacer. What's good for the goose is good for the gander, right? But that Robert Pickerel, he's been tricking them. He'll spotlight. He spotlighted Deputy Keith Schultz. Keith Schultz snuck out there and fucking caught him. Like 9, 10 o'clock at night, it's dark. And Robert Pickerel is, just sitting out in the fucking dark, apparently, right? And I was like, why don't you test it? Why don't you just flick a light on over at him? And so I walked out to the, front of the road so it's not in the same position. And then Keith Schultz flicks the light on over at Robert Pickerel, and guess who flicks the light on back at Keith Schultz? Keith Schultz goes down with the bullhorn and tries to talk to him and tries to engage with him, tries to get him out of the house. He doesn't come out of the house. He stays inside the house. So that's fucking genius, right? Well, how long does it take for a crime to happen? Just think of the most fucking heinous crimes out there. It doesn't take but a fucking minute, if not less. 1 minute, 2 minutes, maybe 1 second, maybe fucking 10 seconds. I mean, just to steal something, right, is just reach over and grab and then run, right? Grab and dash. Isn't that the lingo? Isn't that the street lingo? What's good for the goose is good for the gander. You say warning shots is felony menace, and I disagree. I don't agree with that. No, I don't. I think if everybody was firing warning shots at people messing around their houses, I think it'd be a better world. I think it'd be a better world if we all had guns in every single house. And we all had dogs, and we were all cool with the dogs. And we all knew each other, but not, really. So, you do, but you don't. And then after, 10, 20, 30 years, eventually, even if you don't know the person, you get the sense that if after 50 years they haven't, grab and dashed something out of your house, they probably won't, right? If you can't be persuaded with, convincing rhetoric, then you should be convinced by people's actions. Actions speak louder than words, they say. Don't you know what they say? So, yeah, that's my point. Whatever evidence Robert Pickerel can put into evidence, whatever, criminal procedure I go through, he has to go through. At the end of the day, one side presents their case, the other side presents their case, and then the jury says guilty or not guilty, and then there's a whole 10-step procedure, right? There's a disposition, there's a preliminary hearing, first appearance, and reading of charges, and pre-trial readiness conference, and, la-di-da. Should be fair. It should be fair. So what are the rules of evidence? What's the procedure? I know the procedure, and I know a lot of the CRS and the Constitution. I read it, so I'll tell you what the rules of evidence are maybe tomorrow or the day after.